and my colleagues would like for me to be a little more dramatic, so I'm going to try to accommodate them the best that I can as we proceed. What we're talking about, or when we left off, what we were talking about was basically going through the cases that the state suggested demonstrate that the bad character other acts here were admissible as intrinsic evidence. And to the extent that I didn't make clear when I keep referring to the state's brief, I assume that the court understood what I was talking about when we argued that motion for severance. At that time, Mr. Boring went ahead and made a rather complete argument about the admissibility of other acts evidence as either intrinsic or 404 evidence. And so that's the brief that I'm referring to. So picking up with some of the cases that the state is relying on to that effect, Sullivan versus the state, 284-358, that's a 2008 case. In that case, the defendant paid someone to kill his wife. There was evidence of motive that was admissible, that the wife was making the divorce difficult and that the defendant in that case was trying to secure a loan. There was in fact a direct nexus between the theory of motive and the killing. She was killed on the day the divorce hearing was scheduled. A week after the murder, the defendant called the bank to complete a refinance, which he could not have done when she was alive. I don't think otherwise this case is instructive. It doesn't really have anything to do with the admission or exclusion of intrinsic or res geste evidence. But again, this is what the state cites. State relies on Riley versus the state, 278 Georgia 677. In that case, a father was convicted of murdering his children by fire in the trailer. So some of the evidence that came out, he had used derogatory terms about the children, threatened to kill the children, wished the children were dead, didn't try to save the children from the fire, rarely interacted with the children, was facing eviction, denied welfare, and his eviction hearing was scheduled for 2 days after the fire. Defense sought to exclude evidence of financial difficulties, marital problems, and the treatment of his children. The financial problems evidence was admitted to show a financial motive for the murders. Of course, here we don't have any such financial problems. Certainly in the discovery, we discussed that earlier today. Evidence of marital problems and romantic relationships in the Riley case was admitted to show that Riley viewed the children as a source of friction between himself and his girlfriend. In other words, again, there's a direct nexus between his romantic relationships and the children as a source of conflict. And here, there's no such evidence of any prior difficulties between Ross and his son, or that his son was in any way the source of any conflict with anyone, with some girlfriend or with his wife. Any alleged motive evidence of infidelity or sexually related communications is simply inconsistent with the actual discovery that we received in the case regarding the feelings that Ross had for his son. So I don't think that case in any way supports what the state suggests that it does. The state relies on Fargason, F-A-R-G-A-S-O-N versus the state, 266 Georgia 463. That's a 1996 case. Mother smothers her 6-year-old daughter to death. And the state's motive theory was that mom killed the daughter because her boyfriend did not want to raise another family. Defense objected in that case to certain evidence from neighbors about incidents where the mom had left her daughter sleeping at home alone and picked the children up late, and evidence from child caseworkers that the defendant did not hug or show any interest in her child. The court allowed that kind of evidence in to explain the nature of the relationship between mother and daughter. Found therefore that it was relevant to motive. The motive evidence that the defendant didn't care much about her daughter and that the boyfriend didn't want the child around, taken together. When you put that together, obviously in that case, it made it much more likely that the state's theory was viable. In our case, that's just not the case. The bad character evidence here, the stuff that we've outlined in paragraph 7, sexually explicit communications, is not connected to Cooper Harris like it is in the Ferguson case. In those few instances, as we've gone over, where Cooper Harris is mentioned as part of some of these bad character communications, it's completely inconsistent with the state's theory. We're changing directions a little bit. So, in their brief, as part of their argument, the state says, well, if you don't find that it's really intrinsic evidence, if it's not really res gestae, if it's not motive or otherwise intrinsic, well, then these other acts, these bad character other acts of a sexual nature, it's admissible under 404B, other acts. And the state cites Bradshaw versus the state, 296 Georgia 650, a 2015 case, and I think that my recollection is that in their brief they're citing that really for the general premise of what the law is, which is correct. The 11th Circuit has a 3-part test which our Supreme Court has adopted for consideration of this other acts evidence. 1, the evidence must be relevant to an issue other than the defendant's character. 2, the probative value must not be substantially outweighed by its undue prejudice. And 3, the government must offer sufficient proof that the jury could find that the defendant committed the act. Well, in the Bradshaw case, the evidence of a out-of-state murder was relevant to motive in the Georgia murder because it demonstrated the defendant's willingness to use violence when he or someone close to him was cheated in a drug deal. Of course, in this case, there is no such similarity. Bad character here is just that. It's just other acts. It does not evidence motive. I want to cite one case for the court, really just because I think it's a good instructive case, kind of how to look at this evidence, and that's Amey, A-M-E-Y, versus the state, 331 Georgia Appeals 244. That's a 2015 decision. The Court of Appeals really kind of methodically looks at challenged 404B other acts evidence, and you can see that it's a much more comprehensive review than what we're accustomed to under the old similar transactions analysis. In that case in particular, it was an armed robbery and aggravated assault case. The defendant objected to admission of evidence of an unrelated attempted robbery which took place 3 years earlier. The trial court rejected the defense argument that the older robbery was inadmissible because the state failed to prove it was relevant to an issue other than the defendant's bad character. The Court of Appeals applied the 404B test and concluded that the evidence didn't prove identity as a signature crime, didn't establish motive, didn't prove specific ability to commit the crime, and the judgment of conviction was reversed. Now, this case, we're going to apply 404B to this case. The only thing the other acts go toward, bad character. Evidence of this, any graphic sexual communications or infidelities or actions, again, that would be relevant to motive or relevant to the nature of the relationship between the parties if this was a spousal murder case. It is not. Here, it's just bad character. What the state's trying to get in does not evidence the nature of the relationship between father and son. Bad character sexual communications does not evidence a motive to kill. Certainly not in this case, based on the discovery we have about the actual nature of the relationship between the parties. In making this analysis, I submit the court has got to take into account that actual evidence of their relationship. The court can't just find, well, it's evidence of motive without consideration of the fact that the state's evidence demonstrates a loving relationship. That's what the discovery demonstrates. That's what we've got. The bad character other acts doesn't go toward identity. It doesn't go toward a modus operandi, some sort of signature crime. Other acts of sexual communications or infidelity doesn't go toward intent or absence of mistake. Certainly not for murder. It doesn't go toward opportunity. And of course, we've discussed already at great length today why it's not evidence of motive. So what are we left with? Well, the only purpose of such other acts of a sexual nature is general bad character. And these bad character other acts the state wants to introduce are the most prejudicial in nature. As I've outlined in paragraph 7 of our motion, we're talking about matters that are sexual, that are graphic, that are uncomfortable, things that are just by their nature, they're general bad character, even if they're not unlawful. And in this case, they're probative of nothing but just that, general bad character of a sexual nature. Now, if the court finds that the other act's evidence at issue here is in fact somehow relevant under 404B, of course the court must then apply the Rule 403 balancing test. Now, under 403, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. This case, this is what the court has to weigh. Ross Harris is charged with murder. It carries a mandatory life sentence. The case involves the death of a child less than 2 years of age. The man on trial is his father. The state's discovery that we've received includes no history of neglect, no history of physical abuse, no history of indifference toward his son, no evidence of prior difficulties. The state wishes to introduce evidence, as I've outlined in paragraph 7, of defendants' infidelities and sexual communications and the like over a period of time, possibly even before the birth of Cooper Harris. I'm not talking about the day of Cooper Harris's death. I'm talking about days, weeks, months, and years before. And there's nothing about these graphic sexual communications or actions directly connected to the death of Cooper Harris, so it's plainly bad character evidence. Information unrelated to the child's death, which reflects badly on his character in the eyes of the jury, even if we're talking about something that's completely lawful. So, is that graphically sexual information got any probative value as to the death of Cooper Harris? That's the first thing this court's got to consider. Has it got any probative value to that issue? Because that's what we're here for. Is there some actual nexus between Mr. Harris's unrelated sexual activity and communications and the death of Cooper Harris, given what we know? No history of neglect, no history of indifference, no history of abuse, no history of prior difficulties. And the actual communications which did involve Cooper Harris, certainly at least what we've received, shows a loving relationship between father and son. And so if this court does find some relevant proper purpose, the question I think that's got to be answered is there really any way that the admission of such graphic sexual information is not substantially outweighed by the unfair prejudice? Can the court really make a finding that Mr. Harris would not be unduly prejudiced on a charge of murder of a child if the jury hears and sees every sexually related indiscretion or graphic sexual activity or communication and filthy languages or images, even if it's not unlawful? Can the court really find that he's not going to be unduly prejudiced by that kind of other acts, evidence that the state wants to get into? I want the court to consider particularly one case out of the Seventh Circuit. You got Lori. United States versus Lori, Loughry, 660 F. 3rd 965. This is a Seventh Circuit case from 2011. Defendant was charged with distributing child pornography in an online depository which included exhibition of girls' genitals. He was ultimately indicted for conspiracy to advertise child pornography. Over the defendant's 403 objection, the undue prejudice balancing test, the trial court admitted evidence of uncharged hardcore pornography, which was discovered in the defendant's very home. This was hardcore pornography that he was not formally charged with. It was other acts. On appeal, the Seventh Circuit found that these uncharged acts, evidence of pornography, should have been excluded under 403 because even though he was charged with conspiracy to distribute porn, the hardcore porn found in his home created an unfair prejudice, meaning undue tendency to suggest decision on an improper basis, commonly, though not necessarily, an emotional one. The evidence was the kind of highly reprehensible and offensive content that might lead a jury to convict because it thinks that the defendant is a bad person and deserves punishment regardless of whether the defendant committed the charged crime. Although relevant to show his purpose in joining the online depository was to get child porn, the probative value of the hardcore child pornography was minimal and the risk of unfair prejudice was substantial. Seventh Circuit went on to say this: evidence is unduly prejudicial if it creates a genuine risk that the emotions of the jury will be excited to irrational behavior, and the risk is disproportionate to the probative value of the offered evidence. The court in Loughry recognized that some sexually based displays have a strong tendency to produce intense disgust, which can result in overwhelming prejudice against the defendant. In Loughry, he was charged with a pornography-related offense, and yet the Seventh Circuit in that case found that even though he was charged with a porn case, the admission of other porn was so prejudicial it required a new trial. Here, the state wants to introduce graphic sexual testimony and evidence of uncharged bad character and acts of a sexual nature, which will do exactly what the court in Lori is warning us of. I imagine the state may suggest that any communications on the day of Cooper's death, on that day, are just res gestae, and admissible for that reason alone, such as the Whisper app, which Mr. Boring brought out in a prior hearing. Someone posted that morning on Whisper, which is a communication app. I hate being married with kids, and then goes on to say, laments that they feel unappreciated, like an unappreciated wife with two little ones that drain out the best of me. Now, apparently on that day, Mr. Harris responds with some sort of words of encouragement that we all need an escape. I imagine the state's going to suggest that that kind of communication occurring on the day of Cooper's death is res gestae, so it comes in without applying the balancing test. Well, I submit to the court that's not at all the case. Nor does it suggest that all similar type evidence to that would automatically come in without being subjected to the 403 balancing test, even if it's res gestae. Now, the state's going to argue, I would expect him to argue, well, he's charged with sexual exploitation in count 6 and dissemination of harmful materials to minors in counts 7 and 8. So the state says, so the other acts all come in as intrinsic continuous pattern of behavior for those counts, counts 6, 7, and 8. Or at the very least, any other acts of sexual activity and communication come in under 404B, other acts evidence. Again, like we used to call similar transactions. So I suggest the state's going to say, well, Judge, if you recognize the other acts of sexual communications or infidelity aren't really intrinsic or res gestae as we suggest, or excuse me, if you believe they are other acts under 404 or intrinsic, well, we want to bring in all. We want to bring in all of the sexually related activity. Why? Well, because it should come in under count 6, 7, 8. And this is exactly the bootstrapping that we warned the court about and we talked about when we argued the motion to sever. And so we're back to that by trying wholly unrelated counts together. I submit the state's going to suggest, well, that's too bad. If you don't think it comes in on counts 1 through 5, it's going to come in on counts 6, 7, and 8. So there's 2 points I want to make real clear about that. One is just because there's some evidence relating to count 6 that might naturally come in during the trial, during the murder trial, because of the timing. It does not mean that all of the counts have to be tried together. And I'm sure I made that clear during the motion to sever, but I want to reassert that now. Yes, there might very well be some evidence about count 6 that would come in anyway if we only tried counts 1 through 5. But that doesn't mean they have to be tried together. And the problem we got is by trying the unrelated acts, unrelated victims, the state wants in evidence not only the evidence directly to count 6, but any and all intrinsic evidence or other acts evidence under 404 that relate to count 6. And as we argued previously, and we'll reassert now, severing counts 6, 7, and 8 will cure that dilemma. And the second point I want to make is that just because counts 6, 7, and 8 are joined does not, doesn't relieve the court from ensuring that the state does not get into evidence of a graphic sexual nature which is still far more prejudicial than probative, thereby denying him a fair trial on counts 1, 2, 3, 4, and 5. I don't think there's a better issue that the court really has got to consider than the fact that in counts 1, 2, and 3, he's facing a mandatory life sentence. In count 6, the maximum he can get is 10 years. In just a few more points I'm going to make here, Judge, in considering the if bad character other acts evidence is admissible as to count 6. There's a line of cases I'd ask the court to look at. Simpson versus the state, 271 Georgia 772. It's a 1999 case. Our Supreme Court looked at what and how sexually explicit evidence comes in on a trial in a sexually related offense. In a prosecution for a sexual offense, evidence of sexual paraphernalia found in defendant's possession is inadmissible unless it shows defendant's lustful disposition toward the sexual activity with which he is charged or has been of mind to engage in that activity. Under this rule, sexually explicit material cannot be introduced merely to show a defendant's interest in sexual activity. It can only be admitted if it can be linked to the crime charged. Only if it can be linked to the crime charged. Yes, these cases were pre-change in the evidence code, but I think this is all still good law and instructive on how the court's got to weigh the prejudice component. Frazier versus the state, 241 Georgia Appeals, 125. This is a 1999 decision. Defendant's charged with child molestation. Defendant objected to the introduction of uncharged other acts of pornography, videotapes, sex toys, and some other matters. But none of the other acts evidence were actually linked to the crime charged. None of the other acts evidence concerned sexual contact with a child. And in this case, said it again and again and again, the state wants to introduce bad character of other acts of a sexual nature that are not linked to the crime charged, nor involve sexual contact with a child. Any bad character, other acts, evidence concerning consensual sexual communications, images or other activity between defendant and a person legally able to consent to such communications or contact would be nothing more than bad character evidence of a general lustful disposition. It's not relevant and far, far, far more prejudicial than probative. I think the law is very clear that other act evidence of general lustful disposition is inadmissible unless it shows defendant's lustful disposition toward the sexual activity with which he is charged. And in this case, all of these other acts evidence of bad character, they don't. They absolutely don't. And therefore they're not admissible. So for those reasons, Judge, we're asking you to grant our motion in limine and exclude the bad character evidence of which we have outlined in paragraph 7. It's neither intrinsic nor admissible under 404B or the 403 balancing test.
Judge, I think one thing to point out right off the bat in discussing some of these arguments, just touching on a little bit of what Mr. Kilgore said regarding some of the comments the defendant made about Cooper to these other girls he was talking to online and in person and things like that. I would just say oftentimes actions speak a lot louder than words. I think that's what this case is going to show. In talking about some of his arguments regarding the times that his client, the defendant, may have said he loved Cooper to one of these girls, or he may have said that he adored Cooper to one of these girls. The two girls he specifically referenced, two of them, one was 18 at the time, and the other was 16 and then 17. These are young girls he's talking to and trying to basically get into sexual conversations and do sexual acts with these girls. Obviously, he's not going to run up and say, hey, you want to go have sex with me? By the way, I hate my child. Or I want to kill my child. Of course not. It's kind of analogous to, I think, several of us have had friends who, let's say a guy friend of ours has a dog. Talks about going, well, I'm going to take him to the park. Why? To go pick up ladies. You're taking the dog to the park, you're going to pick up ladies, you're talking about this thing. That guy doesn't go run around and kick the dog in front of the girls while he's trying to pick him up. Of course, he's not going to do that. In this case, the defendant is telling these girls what they want to hear to get what he wants. And we'll just talk briefly in a second about some of the things he also said to these various girls during the time he was trying to start relationships with them and things like that. But I think what also speaks volumes, as Mr. Kilgore alluded to, and kind of sums it up, is what he said 10 minutes before locking that child in a car to somebody anonymous, somebody that didn't really know his identity. 10 minutes before he locks that child in the car, he tells this person who had posted about hating their marriage and tired of the novelty of having kids and then it's worn off and they're exhausted. The defendant didn't say what Mr. Kilgore said. He told this anonymous stranger, not words of encouragement, but specifically about his son. I love my son and all, but we both need escapes. 10 minutes before he locks the child in that car to die. They spoke at length about the fact that these conversations with these girls, he would talk about beach trips and things like that. They would go on beach trips and things of that nature. Well, yes, and while he's supposed to be on vacation with his wife and kids, he's busy sexting all these other women. And additionally, he actually got in an argument with his wife about even taking Cooper on this vacation. Even taking Cooper on this vacation. There are actually text messages back and forth between them. He did not even want to take his child on that vacation. There are text messages between Leanna and another person talking about how she and Ross were arguing and that she wanted to take Cooper on that beach trip, but the defendant did not. And there are also searches about not just the fact that he wanted to go on this vacation. I think there was some cruiser trying to plan for October, but also searches for types of resorts that don't have kids and things of that nature. So it cuts both ways. Additionally, they talk about going to the Braves game. He even sent one of these girls a picture of him and his son at the Braves game. Braves game he's supposed to be enjoying with his son. Meanwhile, he's sending pictures of his anatomy to random women. And Your Honor, I think through these other acts that we're going to have to talk about, I think it's very important to show how extensive this is, to show how important these things were to him as compared to his family. Now, just to start with, initially I created a PowerPoint on it. Feel left out since the defense had on some other occasions, but I did this because in getting ready for this hearing, we've got the new evidence code, we've got the new other act. I say new, it's been a couple of years now. But as I reviewed some of the case law both here in Georgia and federally, there are some things I didn't know that I came across in doing this. So I figured it would help me get through it and help maybe explain what I found to Your Honor and the defense regarding 404B notices. So first of all, what is the reason, why did we file the notice that we did in this case? First of all, as we discussed at the motion to sever, there is, we believe, no reason or no notice that is required in this case. We believe that the things we're going to talk about are intrinsic. We believe that there are circumstances immediately surrounding the crime and evidence of motive. And Judge, we already argued this, and in your order you discussed and found specifically that these types of acts would fall under that law. While not ruling on their admissibility at the time, in order to deny the motion to sever, you found that. Additionally, we filed this motion because in anticipation of the defense filing a motion to exclude. In discussions with them, they said that they were going to be filing something like that. So we wanted to do that in anticipation of the defense motion to exclude. And also because this new evidence code, it is fairly new and the state authority is still developing, still trying to decide how they're going to interpret things. So out of an abundance of caution, in addition to having it ruled upon as being intrinsic and no notice being required, we have given notice in any event just to be safe. And we believe that it is admissible for several reasons under 404B as well. First, with intrinsic evidence, Your Honor, I'm not going to belabor it. There are actually a ton more cases that I put in my bench brief that Mr. Kilgore did not cite, and I've already argued it before, so I'm not going to go through and rehash every one of those cases. But generally, if the evidence is intrinsic, as it is going to be in this case, it's admissible. If it arose out of the same series of transactions, is necessary to complete the story of the crime, or inextricably intertwined. And the courts have also found that it pertains to context, motive, or setup of the crime, linked in time, circumstances of the crime, or forms an integral and natural account of the crime necessary to complete the story. Judge, in this case, there's also a more recent case from the Court of Appeals. It's Bonds versus State, B-A-U-G-H-N-S. That's 2016 Georgia Appeals Lexus 42. That was a case from a couple of weeks ago from the Court of Appeals where they actually addressed intrinsic evidence and for one of the first times went to a detailed analysis of how we are to interpret that. And it's much like the federal authority that we cited before. I do have a notebook of the law that I'm going to be discussing to Your Honor. A lot of it just talks about things we've already discussed. A copy for defense. And I'm not going to go over each of these cases, Judge, but I just want you to know that we did do the research and we have it here to present to you to review when we're talking about the specific findings in 404B, intrinsic evidence and otherwise. First of all, or next, in addition to it being intrinsic, no notice is required if the circumstances immediately surrounding the crime, the evidence trying to show is part of that, or if it's motive evidence. So I think the most obvious reason this is admissible in this case is motive evidence. However, even though there is no finding that we give any kind of notice, we have done so anyway. Also now, this is one thing that I've just recently realized, notice and hearing requirements now are governed exclusively by 404B. The Superior Court rules have specifically deleted 31.3, the notice that we used to have where we'd have to put a date and a transaction and things like that. That's been specifically deleted. And the federal rulings regarding a 404B notice specifically say that the state is not required, the government is not required, and does not have to provide dates, times, places, or persons, or even the evidence that they're going to show in support of with their notice. However, in this case, Judge, we did do that, and not only that, we have turned over all the evidence we have and have been turning it over on a continuing basis, not only in the case in chief, but also anything that would be considered 404B. So the general standards for admitting evidence under 404B. For the other act to be admissible, the state must show, first, the evidence is relevant to an issue other than the defendant's character. That's what we used to call the proper purpose prong of the similar transactions, basically motive, intent, knowledge. In this case, we've alleged motive, intent, knowledge, absence of mistake, or Absence of accident, also plan and preparation. In addition to showing that there is a purpose other than just bad character, we have to prove that there's sufficient proof that the defendant committed the act. That would actually be done at trial. Your Honor is not required to make a finding, and we don't have to actually prove it here in court and show it and connect it up right now. We do it via proffer. And then finally, we have to show that it would be admissible under a 403 analysis. In this case, we've got the relevant issues. First, we've got motive, which we've argued at length in the motion to sever. I don't think I need to reiterate that. Also, intent and knowledge. The cases that have come out recently in the state, and it's very clear via the federal authority that I've provided as well, hold that when the defendant signs a plea of not guilty in a trial, the issue of intent and the issue of knowledge is at play. And the state is allowed to bring in other acts to show and to meet that burden of proving the intent and knowledge in this case. So by pleading guilty, they have made intent a central issue. And Judge, I don't think they're going to run and hide from that. That is going to be the argument of this case. They're arguing this was some accident. We're arguing it was intentional. So intent is central to this prosecution. Also, Your Honor, absence of mistake or accident, and to rebut the defense arguments. That is another reason for why this is going to be, we're going to be asking to admit this evidence. Through the defendant's custodial interrogation, he started by saying he had no problems in his marriage, everything was good, this was an accident, he had no reason to have left his child in that car intentionally. However, we are allowed to, and we're going to ask you to be able to show otherwise in this case. Just briefly, one case that I'm thinking of while we're on the subject of these proper purposes, the defense argued the Amy case. I would point out that that Amy case was centrally argued about the issue of identity and whether it was sufficient and whether the act should be allowed for identity in that case. I would point out that the Amy decision was actually decided before the seminal cases of Frost and Jones, which address and talk about 404B from the Georgia Supreme Court. So Amy is completely distinguishable and was before we've had the edicts from the Supreme Court of how you actually address 404B. In addition, 404B does not have an exclusive list. While there are purposes listed out in the statute specifically says that it's not exclusive, and that if there are other reasons not listed out in the statute for which it should be admitted other than bad character, that can be used as well.